The case against the 5 men arrested for the murder of Bafana Bafana captain Senzo Meyiwa has adjourned for the day. The trial was brought to a premature close due to problems with recording equipment. The state's first witness, Sergeant Thabo Mosia, returned to the stand for cross-examination again today, where he conceded that he does not have a forensic qualification. To unpack today's proceedings, we're joined as ever by our reporter Adv Mnisi, who's been tracking the trial, as well as legal analyst Adv Mkhululi Stubbs, who's with me in studio. We'll begin with you, Linda, and talk about what was discussed around the issue of qualifications and what the point of that line of cross-examination was today.
Well, today you would have heard Thembekile Advocate Zandile Mshololo looking into Sergeant Thabo Mosia's education and qualifications, and she says that the reason why she wants to pursue this line of questioning or this kind of evidence is because of the way in which Sergeant Thabo Mosia has presented the evidence before court. Now, he's asked about the issue around his qualifications and of course his knowledge around gathering the evidence and forensics, and he did in fact make mention of the fact that he did take a course within the SAPS, and that course allowed him to be able to later get a B.Tech in forensics. And the interesting part about this piece of evidence, Thembekile, is that this particular certificate he obtained just a year prior to Senzo Meyiwa's passing. And this means that at that particular point, he just had that certificate, an internal certificate from the SAPS. Let's take a listen at what he had to say about his qualifications.
You know why the reason you cannot be able to answer this? It's because this is forensic. This is part of forensic investigations, which you did not have qualifications of it.
Forensic investigation is broad.
I would like to explain that forensic on its own is very broad. And
now, kamahanyo ya kale forensic, jwalo ka se ke tlhalositse ke criminalistic expert la ke le ka tsiba sala ka tsela e seng yona ka tsela lekgotla.
And I would like to put to the attention of this court that I am a criminalistic expert, even though I was introduced incorrectly in this court.
Yeah, so now you're changing the qualification, you're changing your status now, Mr. Mosia. You're telling this court that you gave wrong information in your examination in chief. Now we are correcting your status now. Is that what you're saying?
Ke tlhalosa hore forensic investigation nna lengolo le ke nang le lona mosebetsi ke criminalistic expert in forensics.
I was actually responding on the fact of forensic expert. The qualification or the statement, the certificate that I have is for criminalistic expert in forensic.
Let's talk about that then. We're still joined by Mkhululi Stubbs, our legal expert tonight, making sense of another day in the Senzo Meyiwa murder trial, the trial of the 5 men at least arrested for allegedly killing Senzo Meyiwa. So we've got today a lot of time spent, Mkhululi, on whether Sergeant Mosia is got a solid qualification as a forensics expert or a criminalistic expert in forensics. How important a distinction is that to make at this stage in the case? At this stage, rather.
Thanks very much. Yeah, so it's an interesting answer, I would say. In one sense, it matters not at all, but in another sense, it matters very much. So let me start with the beginning. Why it matters not at all. The officer is there as a factual witness. He's not there as an expert witness. That is important because of the fact that an expert witness's qualifications would be important in order to qualify the expert to testify about facts. The gentleman is there as a factual witness and not an expert witness, so why is it that we are asking questions about the qualifications? The answer is captured in a Latin maxim. Falsus in uno is falsus in omnibus, which means if I cannot believe you about one thing, then how can I believe you about everything? So what's really being asked or being probed by Advocate Mkhululi is, are you credible when you say that you have this qualification? Because if you would lie about your qualification, how can we believe you beyond a reasonable doubt? about your evidence.
And Linda, around the issue of whether there was a misrepresentation of the qualifications, is it that Sergeant Mosia was introduced incorrectly, or did he mislead the process, the court rather, about his status as far as qualifications are concerned?
In fact, Mbegile, you're taking me back to one of the things that he made mention of during the time when he was testifying last week. He was asked, in fact, around why he allowed Sergeant, in fact, Brigadier Ndlovu to show him or point out certain parts where he needed to collect evidence. And he said, while that happened, while, Brigadier Ndlovu was the one that was showing him around, he, as the expert, collected evidence. So we've been hearing this word that's been used around, loosely around this expert, and he's been calling himself and referring to himself as the expert. We're hearing today that, in fact, according to his qualification, that is, in fact, not the truth.
And his work again at the scene was also questioned today by Advocate Mkhululi, the focus today being on the booking of evidence and the issue of the blood splatter evidence which was not gathered from the car that was used to drive Senzo Meyiwa to the hospital in Vosloorus in 2014. How did he respond?
You'll remember that that question and the context behind that question is the witness statements that we heard in court, where one of the neighbors said there was in fact a cleaning of the scene, where she details how she walked into this house after they had heard that there was a shooting, and they found water on the ground, and they questioned why there would be water when in fact, they had been told that there was a shooting. Also, there was the removal of the alcohol at, inside the house. And what the line of questioning here that Advocate Mkhululi is pursuing is the issue around where exactly Senzo Meyiwa was shot and where he was stationed inside the house when he was shot. And if you look at the pictures from the evidence that has been collected, there are no blood stains on the floor where he was shot in the kitchen. In fact, the blood stains that are on the floor are the blood stains in the lounge, which is between the TV stand as well as the couch. In the kitchen, however, we do have pictures of the blood splatters on the wall, which then brings about questions around where exactly he was shot. Why is it that there is no blood in the kitchen? Let's take a listen to what Advocate Mkhululi had to say.
And that exhibit, Mr. Mosia, the bullet recovered on top of the cupboard, is the one that is set in terms of the ballistic report that is linking the accused with this case. Even if you don't know the results of the ballistic, but I'm now telling you to say the very same bullet that we're talking about, that was recovered under the circumstances I've just referred you to, is the one that is set to be linking the accused with this matter. You understand that?
O ka tla o sa tsebe di results tsa ballistic hore di reng empa wa o tsebisa he hore ka baka la di results tseo tsa ballistic tsa bullet hlo ya bullet e fumane hodima carbon e hothing ke yona e amahanyang baqosuwa bana le tlolo molao e. I understand that.
Advocate Mkhululi Stubbs, let me ask you now about your take on how well the defense has done in proving that there was shoddy work, at least at a evidence of forensics level in this trial. Yes, we're still going to hear more cross-examination, but so far, have they been successful?
Yes, so that was a very important qualification, which I agree with. It's still early days. So far, I think that the defense has actually done a heck of a job, if I may say so. And I think that the reason may bear contextualization, which is that when you're a lawyer in a commercial dispute, what you think about is probabilities. When you're a lawyer in a criminal dispute like this one, what you think about is doubt. And when you're a defense lawyer, like Advocate Mkhululi, what she's trying to do, and doing successfully in my view so far, is she's trying to demonstrate to the court that there is doubt about the prosecution's construction, which the prosecution needs to prove beyond all reasonable doubt. If she can establish doubt, then we're already halfway home at the very least.
And is that doubt then directly linked to the question of how suited Sergeant Mosia was to be at the scene in the first place, which is what I would imagine she was trying to prove when she spoke about his qualification and suitability?
Yes, exactly. So I think that it goes in two directions. The immediate direction is the one that you seize upon, absolutely. So if Advocate Mkhululi can do something in order to undermine the credibility of the witness, then it means that that witness's testimony will not have as much weight or will have no weight whatsoever in the final analysis. If she cannot do so, then she'll have to find reasonable doubt elsewhere. So it goes to Mosia's credibility, but it also goes to the reasonable doubt about whether the crime was committed by her client.
And Linda, let me come back to you and talk about the issue once more about the booking of evidence. Advocate Mkhululi basically accusing Sergeant Mosia of tampering with the evidence. There was also a question about what assessment had been taken of how much liquor the people in the house that night in forced arrest had consumed. What was the relevance?
Well, you'll remember, Tembegile, that Sergeant Thabo Mosia had in fact mentioned that he only booked in the evidence that he collected from the scene on the 28th of October. You'll remember Senzo Meyiwa was gunned down on the 26th of October, and that brought about questions around why only 2 days later was the evidence booked in, and explaining Sergeant Thabo Mosia saying that in fact he had arrived, you'll remember, on the 27th, which was the early hours of the morning on the 27th of October, and then he left the scene at the hands of Brigadier Ndlovu, and then came back still on the same day, now with the crime scene management task team, who then gathered evidence, and then of course that evidence, because he says he was tired and he had a long day in the scene, he did not book in that particular evidence, and he only booked it in the following day. He put it in his safe, but did not declare that kind of information during his evidence in chief. So he was asked around why he did not declare that information during his evidence in chief, why he kept it a secret, and he says it's because, of course, he was tired and he had a long day in that particular scene, and that is why he did not, in fact, book in that particular evidence.
Advocate Stubbs, is that proper for a police official to take evidence from a scene to a secondary location and then only book it in at a later time, whether be it a few hours, a day later? Has that greatly compromised the evidence and its status?
Yeah, so I think that that's a really important question. I won't go so far as to say, to impinge the credibility of the officers themselves, but when it comes to forensic matters which are criminal, what is important for the prosecution, which has to prove beyond all reasonable doubt that the charges are proven, is that essentially they need to ensure that no doubt can be established about the credibility of the evidence. If there are gaps in where the officer can account for where the evidence was, that in itself can establish doubt. It establishes wiggle room for a good defense lawyer to say to the court, well, anything could have happened in that 3 hours. How many people were there? We don't know. How many people entered into the area? We don't know. Is that reasonable doubt? That can become reasonable doubt, can become the basis for an acquittal. Yeah.
As we end then, Linda, talk to us about where we're going to go next for the rest of this week, from tomorrow, in fact.
You'll remember that cross-examination will continue, Tembegile. In court today, we had to adjourn due to, court equipment really cutting, and, they've given the rest of the day to the court officials to fix that particular problem. But we're expecting to continue with that cross-examination tomorrow. And one of the interesting elements that came out of today's testimony was particularly around the second batch of the evidence that was collected during Sergeant Mosia's second visit. There you see the bullet projectile. You would have heard in that particular bite there earlier on speaking about the bullet projectile which was found on the second visit, and Sergeant Thabo Mosia saying that he actually did not see it the first time he went to the scene. And this brings about questions for Advocate Mkhululi around whether or not this particular bullet projectile was in fact planted in that particular scene. And what's interesting also about this is that she then mentions that it is the only piece of evidence that links the accused to this crime.
Okay, quickly, I know I said we're ending with Linda, but final one for you, Advocate Stubbs. How does the state save the integrity, or shall I say, the reliability of the evidence of their first witness now that so much has been undone seemingly?
Yeah, so I think that's a really good question. I think that what's important to remember is that when we talk about fruit of the poison tree, if I can use that paraphrasing, it's used sort of around the world, the argument would be there has been an unlawful handling of the evidence, and therefore you should acquit my client. The answer to that in our law is found in Section 35 of the Constitution, 35.5, where it says, in effect, it may be that evidence is obtained unlawfully or irregularly, but that doesn't mean that it loses all of its value. What is important is the judge's assessment of the evidence overall. So that's why I mentioned that it's still early days. Right now, the defense is looking good, but we may still find that there are twists and turns on the way.
Thank you very much. That's Advocate Mkhululi Stubbs. And Newzroom Afrika reporter Linda Mnisi will continue tomorrow to bring you all the latest from the trial of the 5 men arrested for allegedly killing Senzo Meyiwa in Forster in 2014.